comments online, please. Okie doke. This is a meeting of the Health, Occupations and Long-Term Care Subcommittee of the Health and Government Operations Committee. And we have actually 7 or 8 bills on our agenda today. And we will begin with House Bill 103, State Board of Social Workers.
Could we start with
sorry.
Either 475 or 1060? Those are my
You've told me that 100 times. So yes, 475. My fault.
This
Okay.
bill enters Maryland into the Advanced Practice Registered Nurse Compact. The bill establishes specified procedures and requirements for an advanced practice registered nurse to practice under a multi-state license in a party state or remote state. The composition, powers, and responsibilities of the Interstate Commission of APRN Compact Administrators and requirements related to the oversight, dispute resolution, and enforcement of the compact. The bill is contingent on similar legislation being enacted in 6 other states. There are no amendments offered on this. There were some comments and testimony from MedChi and the anesthesiologists raising concerns about the some language in the compact relating to supervision and collaboration that seemed somewhat contradictory, but I'll note that compacts generally should not be substantively amended, or the fact that it's a compact sort of ceases to be. So you kind of have to take the compact as it's currently written.
I've received correspondence from Mr. Wise from representing MedChi, one of the two. And if I could ask Mr. Weintraub, who's representing this, who is the organization that would benefit from this legislation, if he could speak to Mr. Wise's position. Mr. Weintraub.
I certainly don't want to speak for MedChi. Jason Weintraub, on behalf of the National Council of State Boards of Nursing, I will, if that's okay, I'll defer to committee counsel and that message. I don't want to speak for them.
Oh, okay. But is it correct, counsel, as I read, they have no position, they do not oppose the bill? MedChi.
Right. So what I've heard from MedChi is that they would prefer their language, but they don't oppose the bill without that language. It's just they would like to see it amended. And then, as I mentioned, it is a compact. So generally, compact language does not get amended.
And you're saying we don't have the authority to do that?
You could do it, but then you risk the Compact Commission saying that Maryland's not truly a member of the compact because they didn't adopt substantially similar language to the other states.
Okay. Is there a motion? The bill, there are no amendments being offered by the sponsor, by myself. I am the sponsor of the bill. Is there a motion on the bill?
I do have questions if
Certainly, Delegate Riley.
okay. So all right. So during the hearings, I had put down here that and I've had several emails and constituents. I know we had some opposition and testimony that the Nursing Practitioners Association had some issues, and I believe their concern was that it was an outdated nationally. Is that going to affect? Do we know if that's true or not true? Has that been looked into?
Counsel, do you wish to speak to that, or should I?
Well, I think they're when they used the term outdated, I think that they were perhaps referring to like perhaps conceptually. The compact itself is not outdated with regard to whether or not it's still relevant to join it. The compact in its current form is the compact that is out there right now for states to consider joining. There are, and Jason can probably speak to this, some other states that are considering that now. The compact is not in effect until 6 other states actually join the compact. So once that happens, which could be in the next couple of years, if other states pass that legislation, then it would go into effect as it's seen here. This is the current iteration of the compact that is out there for consideration.
Okay, so if it would happen to get out of date or what have you, then ours will automatically be codified to theirs. So it would be updated, or would we have to come back and do further legislation to make it comparable?
I suppose it would depend on what changed. If there were substantial changes to the compact, then the states would have to re-adopt legislation to enter into a new version of the compact. The compact does anticipate the commission adopting like rules and procedures though, which are outside of the legislative process.
Okay, so they could change it that way.
Again,
possibly,
it wouldn't be the substance of the compact itself. Anything that you see in this bill, if that were to change, you'd have to adopt new legislation to reflect that change. But kind of like we have regulations
Gotcha.
that we anticipate being adopted by the executive branch, those kinds of things that happen outside of legislative activity could happen under this compact.
Okay, thank you, Lindsay. Appreciate it.
Would a participating state be involved in the decision-making regarding the compact and any potential changes?
Yeah, the commission would be made up of representatives from the participating states.
Thank you. Delegate White, followed by Delegate Bandari and Delegate Bagnall.
Thank you, Mr. Chair. My first question was answered as it relates to the effective date. But if anyone could expound upon the impact of what this would mean if we were to adopt this now, if we were to pass this, what would the consequences be? Would there be any, again, taking effect is one thing, but what essentially would be the consequences if we adopted and other states may not pass it, meeting the requirement for it to take an effective date of implementation, if that makes sense.
Because it's contingent on 6 other states adopting it, if you don't reach that threshold, then it just doesn't take effect.
It doesn't take effect. So it would just be on the books without any consequences.
Right.
Okay,
Yeah.
Thank you.
I would just say it wouldn't be on the books. I mean, this bill would be in the code. That's correct. Yes, but the compact does not take effect until the sufficient number of states sign on. As you said. Delegate Bandari.
Thank you, Mr. Chair. I would love to hear from Nurse Practitioner Association of MD. Sarah, you want to say where you guys stand?
Sure, thank you. So we want a compact. Unfortunately, this compact, if we could amend it, we would love to amend it. There's about 3 or 4 concerns that we still have with it. And unfortunately, because it's a compact, we can't amend it. So some of the concerns is there's a 20-80-hour practice requirement. We have concerns that the Board of Nursing already has difficulty getting up to speed with licensing and renewals. We hear them just about every day from a member. There is no APRN represented on the national committee. It's the head of the state licensing board, and we have concerns not having a seat at the table. And I do appreciate the folks bringing this bill, that they did put uncodified language to say that there is this advisory committee that would include us. But the reality is being an advisory group to a national committee that can actually make decisions is not the same as being at the table. And so there's a number of nurse practitioners on the call that I encourage you to hear from, but I do also know Kennedy Krieger opposes this bill. I know Kaiser Permanente is also not particularly supportive. They're on the call, as well as psychiatry societies and the anesthesiologists is my understanding. And other groups are also just supportive of our concerns with the bill, a lot of national groups. So thank you.
Does anyone else wish to speak on the bill? Okay, is there a motion? Delegate Bagnall.
Just to clarify, this is consistent with other compacts where it doesn't compel anyone to join the compact. It just joins the state and makes this available to anyone that would want to participate. Is that correct?
Yes, that's correct.
Ms. Russell, followed by Mr. Shattuck.
Yes, thank you, Delegate Rosenberg. And I want to thank you so much for your time and listening to the Nurse Practitioner Association of Maryland and our concerns. You've really been, a great listener in hearing our concerns, and I want to thank you. But as I would like to mention, there are other states that are looking at this bill, but what we have been told on a national level is that there is opposition in New York from nursing groups, in Arizona from nursing groups, in Hawaii from nursing groups, and that the sponsor in Kentucky is withdrawing the bill. So the threshold to meet 7 states is not seeming like it's going to be happening anytime soon. And the Nurse Practitioner Association of Maryland does have some workforce issue solutions that we would love to share with this committee or any delegate who's interested in learning more about that. That would have meaningful changes that could start today without having to wait for that threshold to be met. So thank you.
I just had a visit from a higher authority. Not on this bill. Mr. Shattuck, well, let me hear from Delegate Cullison first. As a member, you're muted, Delegate. You're still muted.
Thought I had unmuted. Thank you, Mr.
Okay.
Chair. I'd like to suggest that there's still so many uncertain things about this bill and the level of opposition, the concern that there's representation missing. I honestly don't see any negative consequences with waiting a year to see if the folks developing the compact would be able to address some of the opposition. So I'm very hesitant to move this bill, I guess is what I'm saying.
The chair is willing to wait, but not yet a year. So I think I would support deferring the vote on this bill, and let's see what further conversation and possible Senate action could have. Does that sound good to you, Delegate?
Yes, that would be great with me. Thank you.
Okay. So, okay, we will put a hold on this bill for today, and it may possibly come up again with the same kind of notice everybody gets for any bill. Okay, so appreciate everyone's participation. Okay, what was the next bill, Council, that you needed to hear?
That's House Bill 1060. This is cremation's natural organic reduction regulation. I circulated amendments from the sponsor on this bill that I'm sorry, this is the bill that expands the definition of cremation to include the process of reducing human remains to soil through natural organic reduction. The amendments that I circulated, rather than specifying that natural organic reduction be regulated exclusively by the Board of Morticians and Funeral Directors, defines cremation for the purposes of regulation by the Office of Cemetery Oversight to include the process of reducing human remains to soil through natural organic reduction, specifies that provisions of law regarding the maintenance of a body do not apply to final disposition using a cremation process that does not involve incineration, removes from the bill provisions that would have altered definitions of practice funeral direction and practice mortuary science, and requires both the Office of Cemetery Oversight and Board of Morticians to adopt identical regulations on registration and operating requirements for crematories that use natural organic reduction, including minimum training requirements, and authorizes regulations for the disposition of unclaimed soil produced by natural organic reduction.
Is there discussion?
You want to move the amendments? Move the amendments?
Move the second.
Mayor, the amendments are moved and seconded. Delegate Bhandari.
Yeah, thank you, Mr. Chair. Are we on this 1060, Bill 1060, right?
Yes.
We are.
Yeah, the morticians, they are, and the funeral directors they are in the opposition of this bill, correct?
Council.
They had some concerns about adopting regulations without some feedback from, I think, the Department of Environment.
And we already passed the bill 869 study bill, that will collect the data, right? Our committee passed HB 869 already. So, I did a little bit of research. I was expecting what the consequences will be in the environment. This is a very new stuff for our state.
This is the current one.
So I would kind of feel not comfortable moving this bill because we already passed 869 for the study bill.
Does that study bill, Council, do you know if the study bill includes this issue or not?
I'm afraid I didn't work on that bill, but I believe it went to
Understood.
public health. So perhaps Delegate Bagnall could speak to it. Did it go through the public health subcommittee?
It did go through the Public Health Subcommittee, and I think it addresses it broadly, but it doesn't speak to the regulatory process. And I think that was part of the the reason that these were sort of complementary bills. Because the other bill is studying the impacts of a variety of death care options, but not specifically not specifically natural organic reduction. I don't know if we have Delegate Kaiser on this call to speak to how the bills are different. Because even in the hearing testimony, they talked about those two bills being complementary of each other, but still somewhat unique.
Mr. Chair.
Yes, sir, Delegate Bandari.
Yeah, so how about putting 1060 into 869, the study bill, before fully passing 1060, since we don't have a data, and the mortician and the funeral directors are in opposition.
That is a worthy for consideration, but my question first would be, what is the status of the study bill? Is it
That
still?
bill's already passed the House, so any changes to that would need to, or I'm sorry, it hasn't passed the House. It's on third reading, but it's past the point of amendment in the House. So any amendment would have to go through the Senate side.
And is either of the two bills cross-filed? Well, it doesn't have, the one bill will be before the Senate. The study bill will be before the Senate. Is 1060 cross-filed?
Neither of these bills is cross-filed.
Okay. I would also add that Delegate Sample Hughes came up to me on the floor to raise some concerns about this bill 1060. So I am inclined to put a hold on the bill and to see what further discussions with the relevant parties could do with regard to this bill and or the study bill. So we're going to hold this bill. So we're now 2 for 2. Okay, thank you very much, Councilor Lindsay. I'll be joining you. Okay, Lisa Simpson is here as counsel. We'll go back to the top, House Bill 103.
That's fine. Yep.
Okay,
So
please
House,
describe the bill. Thank you.
House Bill 103 requires the State Board of Social Work examiners under specified circumstances to issue a temporary license to an applicant who, except for passing the required exam, has otherwise completed the education and experience requirements for a license to practice bachelor or master social work. The board must issue a temporary license if an administrative delay prevents a required exam from being available to an applicant for at least 7 business days. A temporary license is valid until 180 days after the exam becomes readily available. A temporary license authorizes the holder to practice bachelor or master social work in the state only under the supervision of a board-approved supervisor. There are amendments. The amendments provide that temporary licenses may only be issued if the exam is unavailable for 15 rather than 7 days. They authorize rather than require the board to issue temporary licenses under specified circumstances, and they require the board to submit an annual report on whether the exam became unavailable, and if it became unavailable, whether the board issued temporary licenses and other specified information.
Is there a discussion on the amendments? Will someone offer the amendments, please?
I'll move the amendments.
Thank you. The amendments are moved and seconded. Is there a discussion on the amendments?
Mr. Chair,
Yes.
I've raised my hand a few times, but I don't think that you can see my hand, so if it's
No, I
all right.
cannot.
Yeah, that's what I thought, helping you out by yelling.
Thank you.
Thank you, Mr. Chair. I just want to make sure on House Bill 103 that there is consensus from the Board of Social Work.
On House Bill 103, as it is amended, I received notice from the board that they are okay with
And I'm
this version of this bill.
Yes.
There's that.
Thank you.
And the board is represented here today?
Yes.
sir.
Delegate, this is Daphne McClellan, Executive Director of the Board, and we have agreed to these amendments.
Okay. Thank you. Thanks for raising the point, Delegate Lewis. Thank you, Ms. McClellan. The amendments have been offered. Is there any further discussion? All those in favor say aye.
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 Unanimous. Is there a motion on the bill as amended?
Move the bill as amended.
Second,
Seconded. All those in favor say aye.
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 All those opposed say nay. That is unanimous. Okay. House Bill 489. Residential Services Agencies Reimbursement, Personal Assistance Services.
This bill specifies that the Maryland Department of Health may reimburse a residential service agency for personal assistance services only if the services are provided by an individual classified as an employee. There is an amendment that would change the effective date to October 1st, 2024.
And is that bill supported by all the relevant parties with that amendment?
I know MDH had some concerns, and that was a compromise worked out, I believe, with the advocates.
Mr. Chair,
Yes.
bill sponsor here.
Yes,
Thank you,
indeed. Delegate
Lisa.
Lewis.
Yes, sir. Thank you, sir. And thank you,
Don't
Lisa.
call me sir, please.
Oh, my
Go ahead.
goodness. Professor.
No,
Mr.
no,
Chair.
no. Chair's fine. Go ahead.
Thank you very much. And thank you, Lisa, for correctly indicating that the amendment before you has been agreed upon by all of the stakeholders, and it solves the problem that MDH had originally identified as an obstacle for them. The advocates are also on board, and I believe they are present. If Mr. Chair, if they would like to weigh in as well. Thank you.
If they're not, if things look favorable, even without their weighing in, but if you want to weigh in, you can. I don't see a hand being raised.
That
Oh,
was a
Ms.
chance for
McClellan.
you to, David.
Ms.
Rodman.
McClellan, your hand is raised, I believe. Oh, no, that was on you. Okay,
I will
Move the
say,
amendment.
just for full disclosure, that there was some testimony at the bill hearing, and I have not heard anything from, that was the circle of friends, but I have not heard anything from them since then. That might be the circle of friends.
Mr. Petrikov.
Yes, thank you, Chair. Yes, we're here in opposition of this bill. We believe this will increase the dire shortage of caregivers in Maryland right now. There's a lot of agencies that are not in the loop on this bill going through the House. We think it could, with the reimbursement, Medicaid reimbursement rates at its current low level, we think a lot of agencies could be upside down and can cause caregiver disaster in Maryland. So thank you.
Mr. Rodman.
Thank you, Mr. Chair. I'll just note on the question of what workers want to be, workers themselves testified at this hearing and others submitted written testimony that they prefer to be employees. Many don't realize all of the rights that they lose when they're misclassified as independent contractors, which can include some really serious stuff, including paid sick leave, workers' compensation. Injury rates are very high here, health insurance. We're talking about paid family leave right now this session. They won't get that. They also have a higher tax burden at the end of the year. And there's a misunderstanding about flexibility. Some workers believe that they can't have employment flexibility if they're classified as an employee. That's just not true. So workers themselves and their representatives, ranging from 1199 to the National Domestic Workers Alliance to us, the Public Justice Center, and a wide range of others who submitted written testimony and were there to testify orally, all say that it's better for workers. We respectfully disagree. We think that this will address the worker shortage in the opposite direction, make these jobs more appealing to workers. There was testimony from multiple home care agencies that transitioned from 1099 to W-2 employee, that turnover dropped when they made that transition, and that they were able to do that transition in just a few months, that it didn't take that long, and that it remained financially viable for them as home care agencies operating in this Medicaid space. So we think this is a good bill. We think that the compromise in terms of the implementation date addresses all of the concerns Certainly makes it easier for home care agencies that want to transition. They've got a lot of time now to do that. And I'll just leave it there. Thanks very much.
Thank you. Mr. Allman?
Thank you, Mr. Chairman. Yes, so my agency, I'm the CEO of a home care agency in Maryland. We're the largest Medicaid waiver provider in the state, and I'm also on the board of the state of the Home Care Trade Association, MENCA. I would echo what Mr. Rodwin just said. My agency converted about 1,200 caregivers from 1099 to W-2 several years ago. It took us about 6 months to do 1,200. It is work, but it is certainly doable. I think we're testimony to the fact that you don't go out of business when you do this. We're still in business. We're doing fine. Certainly our profitability is less than what it was is because now we are paying appropriate benefits. We are paying payroll taxes. We are paying workers' comp insurance. We're paying Maryland sick and safe leave, which the 1099 agencies largely are not. So yes, it is less profitable, but we feel like in order to be compliant, this is the correct model. It's better for the caregivers. We also think it's better for the patients. So thank you very much.
So you are in support of the bill?
Yes, sir.
Thank you. Delegate Bagnall.
Thank you, Mr. Chair. And I actually want to take a page from the bill sponsor because we had another RSA bill in our Public Health Subcommittee this morning. We committed to writing a letter to the department, encouraging them to look at the wage data. And I'm wondering if we could also, in that letter, encourage the department to make sure that they have an outreach program to notify the RSAs of this change and of the effective date.
Oh,
I don't want to hold up the bill and put it in the bill because I think this is too important a bill. But if we could do that and move this bill and just make sure that the department is notifying so that we're addressing the concerns of Mr. Petukov, who is concerned that some of these small organizations aren't aware of the changes. I would make that request of the body and also move the bill or move the amendments.
Okay.
Second.
There's move and second. We've had sufficient discussion, I believe. So the motion is on the bill as amended.
Move the bill as amended.
Second.
Delegate Morgan. You're muted.
Thank you, Mr. Chair. It took me a while to get my finger unstuck here. This is a pretty major change for a lot of these smaller caregivers. I mean, we're kind of late in session. Them not being notified of this, this is a major hit to their bottom line. And I'm just wondering how many of them know that this is coming.
Well, one, if I'm correct, the amendment, which we've adopted, delays implementation of the bill by a year until 2024. And then Delegate Bagnall's suggestion, for which there appeared to be support, is that for the department to notify adequately, notify those who would be affected of this impending change in 2024. Is there any further discussion from the members?
Mr. Chair.
Delegate Riley, and then Delegate Lewis.
Thank you, Mr. Chair. Yeah, I heard, the opposition, and so those folks are concerned because currently, within the current law, they can operate this way and work as contractors. And I think we've already addressed that they feel that this is going to, take away the workforce. And then the other side says it will encourage it. So, there's differences there. But, one thing it is doing is, forcing these individual, these smaller businesses or large businesses, whether they operate that way with contractors or employees, but you're taking the choice away from the business and you're taking the choice away from the employees that actually work there. We heard from contractors that said they absolutely love this because a lot of them were doing other jobs and this was, a second job. So, which would mean to me that they're actually, doing another job, but yet still have the passion to, work within these homes, and they're available for extra hours. So it's like, an awesome volunteer that's coming in and being a contractor and helping these businesses out. So I don't know that, I see this as, if we passed it, that it's helping. I'm not sure, the driving mechanism. I mean, have we seen problems with, with them following the current law and them being contractors? Maybe Mr. Dave can, Rodwin can, say something about that. I don't know if there's been violations from this or what actually caused for us to come up with this legislation.
Mr. Chair, may I
In
respond?
response to the delegate, I will call upon, recognize Mr. Rodwin.
Thank you, Mr. Chair. Yeah, there's been a really serious problem of violations in this sector, more than almost any other sector that we deal with in the Public Justice Center's Workplace Justice Project. The problem of home care agencies misclassifying home care workers as independent contractors has been really, really devastating. The U.S. Department of Labor has a special sort of focus on this, both in Maryland and nationwide. I get press releases from the U.S. DOL every time they settle one of these or get a favorable result. It's 3 a week, roughly. We've sued a large number of them, to be quite honest. I'd really rather not do that. It's not an efficient way of dealing with this problem. We've never lost one of these. The courts always say that they're employees. And most recently, there was a guidance document that this body passed a few years ago that makes clear that in really almost all cases, these workers are going to be employees, not independent contractors. If they have a wage rate set and they're not free to negotiate with the client what their wages are, then they're an employee of the agency. There's a misunderstanding from some agencies about what the law requires, but the law is quite clear. Many do it anyway because there's 1,700 of these home care agencies in the state. The Maryland Department of Labor doesn't have the resources to provide adequate oversight to all of them. Office of Healthcare Quality doesn't do any employment-related oversight, and the U.S. Department of Labor, I've spoken with the head of the Baltimore office, who's described it as, in his words, whack-a-mole.
Thank you. Thank you, Mr. Rodwin.
Thank you.
Let's hear from Mr. Hafer, whom we have not heard from. Jason Hafer, you are recognized.
Yes, thank you. I was going to echo some of the sentiments that Mr. Rodwin mentioned, that this body, the Department of Labor, the Attorney General, and the Maryland Department of Health released a guidance document last year that clearly stated that in almost all circumstances, these individuals should be classified as employees and instead of independent contractors. So I think there is a pretty widespread concern within the industry that there are people being misclassified.
And who are you with, Mr. Hafer, or are you by yourself?
With Home Centrist Healthcare, thank you.
Okay. Delegate Morgan.
Mr. Chair, just for anybody in the room that wants to answer this, the ones that are logged in now that do own these type of facilities, are your employees currently the workers, as you call them, that work at your facilities? Are they currently 1099 employees, or are they listed as W-2s?
Mr. Allman.
Thank you. Yes, sir. They are, in our case, they are employees. Now, whether they work 40 hours a week or 10 hours a week or 80 hours a week, they are employees just based on labor law. And it certainly doesn't preclude them from getting another job at another agency. You can be an employee at 15 agencies if you'd like to.
Well, I guess my question is, if businesses can do this themselves, why do we need the bill? Just because?
Because they won't, right? So,
but you're doing it.
We did it because let's be fair, we're the largest one, and our attorneys convinced us we'd be the first one where they knocked on the door and hand us an invoice worth several $1 million. So we did it to be compliant with law. And, a lot of them are uncompliant according to the state's guidance document. And this is simply a way to help that, because it's not a level playing field. When an agency has to pay $2 more in employment costs because Maryland says so and the agency down the street does not, that's tough. And what all it's doing is, sort of creating a race to the bottom where the non-compliant agencies are able to operate more profitably. It's tough. This is an enforcement bill.
And I believe it was Mr. Rodwin's testimony that pretty consistently, when actions are brought, that the finding is that these are people who should be considered employees. So this bill would be doing away with that hindrance. Mr. Hutchinson, Delegate Hutchinson.
Thank you, Mr. Chair. Is it possible to do both, though, that you could offer employees employment under a W-2, but have some that want to be special and be 1099?
Mr. Rodwin, briefly.
I'll be quick this time. No, because it's not based on an individual's choice. It's based on the reality of the relationship between the worker and the employer. If the employer has the authority to exercise control over the worker, then the worker's an employee. That includes just merely setting a pay rate is oftentimes enough. So it's not a matter of choice. It's just a matter of the reality of the relationship. Thank you.
But as a follow-up, if you don't mind, Mr. Chair.
Certainly.
But that sounded like that was just your company's or decision to do it that way. Obviously, I've worked for companies where we have W-2 employees, but you do hire subcontractors under a 1099 status. Are you saying that state statute says that can't happen, or that's just the prerogative of the employee?
Mr. Chair.
Delegate Lewis, can you answer that question?
Thank you so much, Mr. Chair. I think it might be helpful to return to the bill and what the bill actually does. The bill doesn't mandate small businesses to do anything. The bill doesn't mandate workers to do anything. All the bill says is that the state of Maryland Medicaid program shall reimburse residential service agencies only for workers who are categorized as W-2 or employees. The small business, the RSA, can choose to designate its workers however it wants. Yet, the state retains the right to use public dollars, the Medicaid dollars, only to reimburse those agencies for their workers who are categorized as employees with all of the benefits that go with employment. Thank you, Mr. Chair.
And thank you very much, Delegate Lewis, for that clarification. Delegate Morgan and then Delegate Rowell, and then we need to proceed to a vote.
So the bill is quasi forcing these businesses, either you take your 1099 employee and convert them to an employee?
No, sir. The state does
or you
not
don't get
mandate
paid?
that. No, sir. You cannot, the Medicaid program will not reimburse the business unless their workers are W-2 employees. They can continue to pursue
I just want to make sure I
revenue in
understand the
other
bill.
ways.
So if the business doesn't convert their independent contractors to employees, the government will not reimburse them for their services that they're currently providing.
Right.
Is that correct?
Is that correct, Delegate Lewis?
Yes, just making sure that I was recognized. Thank you, Mr. Chair.
Okay.
Yes, Delegate Morgan, the state has the right to use public dollars as it deems fit, and the state has the authority to make this,
Do we do it? Do you know if we do it elsewhere?
Thank you for that question. My understanding is that, yes, the state, surely, I can't think of a specific example. Perhaps Mr. Chair, Council could advise on specific examples.
I do not know off the top of my head.
Oh, here's an example, Mr. Chair. Go ahead. So we just left the House floor where there was a vigorous and robust debate about the Boost program. And the question before the body was whether or not the state would continue to use public dollars to fund private schools, essentially. And The consensus of the majority of members in the House was that the state would stop using public dollars to pay for private schools. And I think that's a great example of how the state can use its authority on how public dollars are used. Thank you.
Okay, Delegate Bhandari and then Delegate Morgan and then a vote. Delegate Bhandari.
Thank you, Mr. Chair. I love this bill. The reason is misclassifying PCAs as independent contractors denies them important legal protection and can also result in costly investigation and litigation for RSAs. So I'm voting for this bill.
Thank you, Delegate Morgan.
I'm not really sure. The only thing, in my opinion, this bill actually fixes is a couple people that want to operate their business as independent contractors. And look, to me, that's up to the person that wants to work at those facilities. I mean, if you can work as an independent contractor, there's a lot of benefits to it. Normally is you can write off your expenses for going to work. I'm not sure that the W-2 model really fits for everyone. And to me, you're forcing these, look, the businesses that want to offer this to their employees as to be a W-2 employee. Well, to me, if that's so much better, I mean, I would think that they would have more employees working there. You would have a competitive advantage. But the bill is to address the competitive disadvantage of people that rather work as an independent contractor. So, yeah, I don't know. I think this is a bill searching for a problem.
Delegate Bagnum.
Thank you, Mr. Chair. And I just wanted to get a point of clarification. I think Mr. Rodwin probably has this. You were referring to the guidance doc. Is this bill bringing us in compliance with the guidance that came from the department?
That's exactly right, Delegate. Yes.
Thank you. Thank you very much.
Thank you. Okay. Is there a motion for favorable? Is there a motion on the bill?
Move the bill as amended. A second.
Okay. In light of the debate, I'm going to ask people to raise your virtual hand to indicate your support. So all those in favor of the bill, please raise your virtual hand. Chair sees 6, 7, 8. 8 in favor. Those opposed, please lower your hands. Thank you. Those opposed to the bill, please raise your virtual hand. I guess I should get mine down. 3. Okay, it is 8-3. That was a very important debate, and no doubt we'll have it again in full committee. House Bill 614, Department of Aging, Dementia Care, Navigation Programs. Council.
This bill requires each area agency on aging to establish a dementia care navigation program. The Maryland Department of Aging must oversee and train dementia care navigation program staff and disseminate best practices and collect interaction data to ensure statewide program integrity. There are amendments that were distributed. They renamed the program the Long-Term Care and Dementia Care Navigation Program, make conforming changes. They clarify that under the program, cognitive screening rather than assessments will be conducted. They specify that area agencies will develop a program and implement the program subject to the limitation of funding, and adds providing access and referrals to long-term care and chronic disease services to the duties of the program. And also the amendments alter the formula for funding to consider the number of individuals likely to need long-term care or dementia care services in each jurisdiction.
And is there any opposition to the bill, or what is there a consensus on the bill with the amendments? Council? That you're aware of.
I'm sorry?
That you're aware of. What is your understanding?
So my understanding is that everyone is pretty much on board. The Senate was they were the ones that wanted to include the long-term care. Montgomery County had some concerns. the amendments were attempting to address those concerns, but there's somebody here from Montgomery County who can let us know whether they do or not.
Ms. Frey. I
Thank
hope
you.
I'm pronouncing that correctly.
It's Fry. Thank you. Leslie Fry from Montgomery County Department of Health and Human Services, which is home to our area agency on aging. I want to thank Delegate Collison for her working with us on many of these amendments. They do meet our needs. I did want to bring up the addition of the long-term care access and referral language. The AAAs, I don't believe, would be able to provide access per se to a long-term care facility. At most, I think we'd be able to provide information about how to access long-term care. And we do have some concerns with the chronic disease services language. I would like to hear more, if possible, about what that is driving at.
Delegate Collison, can you speak to that, or is there someone else who can better speak to that?
I was not present at the conversations
Certainly.
about that. So I think if Mr. Colchimero, who was present, I think,
Fine.
at the Finance Committee, can speak to that.
Certainly. Go ahead.
Hi, thank you for the comments. I would just say from a broad perspective, I want to acknowledge Baltimore City for their support of this legislation. I also want to acknowledge Montgomery County for their favorable with amendments testimony. It's through the feedback of our local jurisdictions, and we spoke with many, including but not limited to those two, that makes the process better. As far as the concerns expressed, those were added by Senate Finance proactively, to put it nicely.
It's my understanding that the finance chair was the one who requested the amendments.
Yeah, and I think the thought was that and I don't want to speak for the finance chair, but I think they wanted people who are struggling with long-term care issues to be addressed. And we tried to craft a bill that addressed that. Some of the language says, even if people don't have a symptom of dementia, and it's just they have not a diagnosis, but activities that interfere with daily living, that they can be treated. But as Lisa noted, this was the finance chair.
What is the status of the Senate bill?
It was heard and passed on second reader today on the floor of the Senate.
With those amendments?
Correct.
The Senate version does not include some of the amendments that are
Right, it
trying to
doesn't
address Montgomery County's concerns, but they are aware that those changes will have to be addressed when the bills cross.
If I heard correctly, Montgomery County still has additional changes that it wishes us to consider. Is that correct?
No, Delegate Collison did a great job of incorporating our.
Oh, okay. So you're okay with this bill as amended?
No, sir. With the exception of this long-term care and chronic disease referral issue.
You know, I mean, again, we're going to have to amend them once they cross. I don't know if that could be something that could be, further discussed then. I don't know. The chair or the sponsor of the bill might have an opinion.
Yeah, Delegate Collison, I mean, we could address that problem now, or we could hold on to the House bill and address it in the Senate bill. You're the sponsor, so.
I guess I would like to hold on to the House bill with my amendments and address the long-term care issue when we after we cross it, and we'll.
So you want to pass your bill
with the Montgomery County amendments
and with the long-term care amendments?
No, without
you want to take out what the Senate did with the long-term.
Right, with and responding to Montgomery County's concerns, and we'll confer about it and see if we can work them out.
Okay, is that clear to council and to the committee? Okay, Delegate White, you had your hand up. You
Yeah.
still wish to?
Well, it
Please.
sounds like that there will be further discussions. I just had a question about, again, the question that Ms. Frey raised regarding the notion around access. and how that translates to our local agencies. And so I just wanted to get an understanding of how does that translate to implementation? What does that look like when we're talking about that component of the program in providing access and referrals? I understand referrals, but when it comes to providing the access to that long-term care and chronic disease services, I would like to better understand how does that translate?
Thank you for the question. That was my question too, in that the AAAs can't provide access to long-term care facilities. We have no control over the long-term care facilities. So what we can do is provide information, connect families to our ombudsman program, for example, but we cannot, admit someone into a long-term care facility, thereby providing them access is our concern with that language.
So could we change the language? Would you be comfortable if it said provide information and referrals to long-term care and chronic disease services?
I'm not opposed to that language. I would offer that the ombudsman program essentially does that work already, to my understanding.
Mr. Chair?
Certainly.
But I think we could move the bill faster, Leslie, I just heard you say you weren't opposed to the language that Lisa just suggested. I know it's not a clean way to do it, but I think that will help us to move this if we can maintain I'm reversing myself, Lisa, sorry.
Okay.
On the finance amendments, perhaps with some adjustment on the referral piece.
If that is the strategy, could we possibly consider removing the chronic disease language, as that is really broad and possibly outside of the scope of a AAA? Chronic disease can mean a lot of things.
I would be okay with that.
Okay, so providing information, and we're on page 3, line 16. Did I send around a reprint of this? Yes, I did.
You did.
Okay, so providing information and referrals to long-term care services, and we'll strike and chronic disease. Does that work?
It does for me. I appreciate everyone. Thank you.
With that, could I move the amendments?
So moved. Is there a second? Okay, we're going to move forward. Real quick, Eric.
All right, just a point of personal privilege, Mr. Chair. I just want to take a moment, 30 seconds, to say thank you to Chair Cullison, Vice Chair Cullison. She's been a real partner in this legislation, and I'm really grateful from the Alzheimer's Association.
Delegate White, then Delegate Bagnall.
Okay, very quickly. I know Delegate Cullison, you talked about striking chronic disease services, and I know that is, again, Leslie, to your point, it's outside of the scope of the AAAs. I wonder if there is any interest in still keeping it in there, but just in collaboration or coordination with the local health departments in providing that information or referrals. Is that something that would be of interest, or if we want to strike it out, it's no problem. I just recognize that the AAAs, I understand that may not be within their scope, and the health department could easily offer that in collaboration or coordination with them.
I would ask Leslie to respond.
Given the choice, I think the scope of the bill would be best limited to dementia and related cognitive issues, and not brought into something like chronic disease.
Okay, thank you.
Thanks.
Thank you all. Delegate Bagnall.
Thank you, Mr. Chair. And just for the sake of all of us, Lisa, would it be okay to just walk us through one more time where we landed before we take the vote?
Good idea.
So,
Lisa, are you ready?
On page, you're talking about with that amendment change that we were just talking about?
If you could just walk us through the bill as
hold on.
amended
Okay.
before we take the vote on the amendments in the bill.
Okay, so the bill is going to require the department to oversee and train the staff of long-term care and dementia care navigation programs, and to disseminate best practices and collect interaction data. The work of these programs will be guided by the State Plan on Aging and the Virginia I. Jones Alzheimer's Disease and Related Dementia Council. There will be a reporting requirement to keep track of what is happening under the program. The area agencies will be required to develop a long-term care and dementia care navigation program that consists of new or existing services. And they will be required to implement the programs that they develop according to or subject to the limitation of funding. The duties of these programs, we're adding, and this was the language we were just discussing on page 3, line 16, we're adding that the programs will provide information and referrals to long-term care services. On page 4, we're striking some broad language that would have authorized the programs to do any other appropriate services. And then we are clarifying the funding formula that it will take into account the number of individuals in each of the jurisdictions who will likely need long-term care or dementia care services.
Thank you.
So there is the motion before us, I believe, is the bill as amended. All those in favor say aye.
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 All those opposed. And there remain issues if this bill passes through committee, full committee, and then the House. There remain issues to be resolved in a conference committee.
Yeah, well, I mean, there will be issues that need to be resolved when they cross. I mean, whether we'll get to the point of having to have a conference committee.
Okay, fine. Thank you.
Thank you all.
House Bill 702, Healthcare Facilities, Nursing Homes, Acquisitions, and Licensure, Delegate Cares Bill. Council.
This bill requires the Maryland Healthcare Commission, when evaluating a notice of acquisition or transfer of interest of a nursing home, to provide written findings and recommendations to the Office of Healthcare Quality. The findings and recommendations must include the quality ratings of facilities currently or previously owned by the purchaser, the tax identification number of each purchaser, the personal Centers for Medicare and Medicaid Services certification, number of each purchaser, and a summary of the findings and the basis for the recommendations. The Secretary of Health must consider MHCC's findings and recommendations before taking action to approve, deny, approve with conditions, or revoke a nursing home license. There are amendments that were distributed that include additional quality of care metrics for the Healthcare Commission to include in its written findings and recommendations. And it alters the time frame required for the submission of notice of acquisition from 30 days to 60 days before closing on the acquisition. I will just also note that I'm not sure where the breakdown was, but the Healthcare Commission had submitted written testimony, and I think some of it got dropped off. It was either at that point or at the drafting of the original bill. I'm not 100% sure. So there is additional language that the Healthcare Commission is thinking about adding. The amendments that are before you are the same amendments that the Senate is going to vote on later today. But just so that everyone knows, we're probably going to again, like we're going to have things to address on the bill we just passed. We're going to have a few outstanding issues to clear up after these bills pass too.
But if we pass them in identical form, we can still make changes?
Yeah.
Okay.
Yes.
Is there Ms. Dana Kaufman?
Thank you. And looking at the reprint, I do have one very big concern and one smaller concern. We did support, Lifespan did support this bill at the hearing. However, if you look at the Maryland Healthcare Commission's amendment on page 3, so before I talk about that, remember this bill is about looking at information, gathering more information, and then passing that over to OHCQ, who ultimately has the decision whether or not to approve a licensure. The amendment that's on page 3, though, that's a substantive change. It is beyond just transparency and communication. That basically, the way I read it, and as it may need to be changed, because what they were trying to do is, we do still have some very old nursing homes that have triples and quads. If you're going to build a new nursing home, you can only make it a double, singles or doubles. And what this is basically saying right now is that, that no acquisitions can occur if they have more than 2 beds in a room. And that's a huge substantive change that needs to be discussed, because that's going to hurt those facilities that need to be bought and should be bought. If the intent was to also require newly acquired homes to convert to doubles, that's a conversation that we have to have with Medicaid, because there are caps on expenses and things along those lines. This is much bigger policy issue than what the bill was intended, and that's my concern. I understand the concern about triples and quads, but I will also point that in private pay, those are lesser costs too. And then the other issue that I had, I just wanted to point out, and I think it's probably not the intent, but if you look on page 2, there's 5 new items. But if you look at 4, it says licensing or disciplinary actions against any individual agent, individual or employee of facilities currently or previously owned within or outside the state. That would be every employee of a facility. So if you had 30 homes, you've got to do licensing and disciplinary actions on every employee and report that, which I don't think that's probably what they wanted to do, especially since disciplinary isn't even defined, whether or not that's disciplinary in the state, disciplinary within your personnel record. So I just wanted to point that out, but also to let you know that as part of the OHCQ review, there is already a form that requires all adverse actions and convictions to be reported for the owners and individuals like that. So I think that went way broader than probably was intended.
And is that in the Senate bill?
These amendments, the Senate's voting on them today, I understand, but I received, this is the first reprint I got. I got a sheet at the hearing in the Senate that just had like the ideas, but the Attorney General's office didn't testify at the hearing. They just had submitted written.
Okay, Eric, followed by Ms. Ericat.
Yeah, I have enormous respect for Ms. Kaufman and the industry she represents, who serve seniors with Alzheimer's and other forms of dementia. And I can't address everything she raised. I will say on the retrofitting of beds, though, and making these spaces better for seniors, the cost issue she raises politely is, with due respect, a little bit of a red herring. This is about transfer of ownership to an industry that got over $100 million in following COVID-19. This is about an industry that has out-of-state actors buying numerous facilities in each state. They are real estate investment trusts who are slashing costs and cutting services in some cases, as the Washington Post and others have declared. Many folks are really not concerned about the folks who are purchasing up these facilities and the costs associated. Again, I can't speak to the number of different points you raised, but on the cost front, I would really suggest we look beyond that for these actors, because these transfers of ownership are happening fast and furiously.
Ms. Ericat?
The one thing that would add to the amendments submitted by Maryland Healthcare Commission and the Health Education Advocacy Unit for the
Who are
number
you
of,
with, please?
sorry, my name is Lorraine. I'm with 1199 SCIU.
Thank you. Go ahead.
The letter from Maryland Healthcare Commission with amendments, something that was dropped off was acquisitions with more than 2 beds will have time to reduce those beds. So those acquisitions can still occur if they have more than 2 beds. But there will be oversight to figure out how to reduce those beds within 2 years. So we'll make sure to work with the drafter on that.
Tracy DeShields.
Yes, hi. I'm with the Maryland Healthcare Commission, and I'm just going to respond to what Ms. Kaufman's stated and Ms. Ericott. I wanted to clarify that what Lisa mentioned, the language that was dropped off, so that makes the bill a little bit unclear. But our amendment essentially would require, does not prevent an acquisition from happening. But if a purchaser were to purchase a facility or a nursing home that had multiple beds above 2, 3, and 4, and we do continue to have some of those. And of course, they're in some of the most deprived areas in the state. So if they want to purchase something like that within 2 years, they would need to make changes so that they are no more than 1 or 2 bed arrangements for individuals. We did follow up with Medicaid based on Ms. Kaufman's concern about the cost. And we're told that we don't think that that's an issue or a problem here. Thank you.
Mr. Shattuck.
Thank you, Mr. Chair. My name is Dan Shattuck. I'm here on behalf of the Maryland Continuing Care Residents Association. I didn't get a copy of the reprint. I just wanted to raise the amendments that the MACRA folks had proposed, which was intended to add a little more clarification to who the purchasers are, and just extending that in addition to all the information that was being sought from the purchasers, that each of the individuals or entities that had a ownership interest in the purchaser also provide their TINs and information as well. So again, I didn't have the reprint, so I don't know if those are under discussion, but I would put those forward for discussion.
What's the status of the Senate cross file? Could you remind me, please, Council?
They're voting on these amendments later today, is my understanding.
Is there uncertainty among the members, or do you want to proceed?
Do you want us to unmute and stay? I would move the amendments.
Okay. So any further discussion among members of the committee? Delegate Riley, then Ms. Kaufman.
Yeah, I would feel more comfortable actually seeing the amendments that the Senate does, or maybe hear from Ms. Kaufman and a follow-up. So, because I'm not quite understanding exactly what's happening here. I like the bill, but apparently there's been some changes to it. So I would like to have a better understanding of what those changes really are before I proceeded. Thank you.
Anna.
Sure. And again, I want to just emphasize Lifespan supports the bill, and we don't have an issue with adding some of those additional metrics. But this issue came up just a week ago by the Maryland Healthcare Commission. And our main concern is it could have a very chilling effect on who will want to buy these facilities. And that has always been this balancing, that if you put so many requirements on, you may have a nursing home that needs to be bought that nobody's going to want to buy. And this change is much broader than what the intent of this bill was. This is a substantive change. And without having everybody in the room to talk about it, I'm just very concerned about it. Again, it's much broader than what this bill was intended to do.
Exactly.
Right. I think since we have the bill moving in the Senate, I'm going to hold it here and ask the relevant parties to meet and see if you can reach consensus on the Senate bill and or any other amendments that we would then take up. Okay, thank you. House Bill 774, Council. Assisted living programs, unlicensed programs, resident abuse and negligent and neglect, obviously Attorney General.
So this was the same bill that we discussed last time we met, and Delegate Riley held the bill. It requires the Maryland Department of Health to investigate credible allegations of assisted living residents having been subjected to neglect, exploitation, or abuse when a person is found to be knowingly and willfully operating, maintaining, or owning an unlicensed assisted living program. If neglect, exploitation, or abuse is found, the person operating the program, unlicensed program, must be subject to immediate prosecution. Or if the department finds no reason to believe that residents have been subject to exploitation, neglect, or abuse, MDH must provide written notice to the unlicensed program requiring compliance with licensure within 30 days. The amendment specified that the Office of Healthcare Quality will investigate an allegation if the department does not add exploitation to the allegations that will be investigated, and specify that all abuse and not just physical abuse will be investigated. The amendments also authorize the department to adopt regulations.
Delegate Riley, do you have comments on the bill and the amendments that we?
Yes, thank you, Mr. Chair, for holding it for me. I was able to get a little bit of information. It took a while, but so the only thing that I have, so in the fiscal note, it did mention the that the licensure process was COMAR 10.07.14. So I was able to get a copy of that. So I'm not sure if this is exactly once they go into this location and they have the 30 days to to come up with a licensure or license. There's a lot there. So my concern was, in doing this, are we going to take away a home, a resident that actually provides services to our elderly that either don't qualify for Medicaid, so which then it's very expensive for them to go into a nursing home. And so a lot of people, I'm sure, use this avenue to put whomever, those that are elderly, and it's reasonably, financially suitable for them. So are we looking to close all of those establishments with if they have more than one bed? And if they do have more than one bed, then they have to go out and get this full licensure process, which is pretty detailed in the COMAR. So that was my only concern. And then also, the catalyst of why we are even looking at this bill was another concern, because we didn't have any data of, locations that have been in violation of really, treating our elderly, in a proper way. Obviously, we all, when we get to that point, we want to be in a nice location. But I'm just afraid that this is a huge market that we're taking out for our citizens to actually have the opportunity to use. And that, again, I'm all for, making sure that we treat our elderly well. But I had concerns. So that's why I tried to hold the bill. And looking at the COMAR, it's pretty intense. So I still have concerns on that avenue. So if someone could address those, that'd be
Ms. Ellis, thank you.
Thank you. My name is Stevan Ellis. I'm the State Long-Term Care Ombudsman. I actually worked with the Attorney General on this bill. The Ombudsman program is an advocacy program for nursing home and assisted living residents. What happens is we have licensed assisted livings that take care of two or more unrelated people that need assistance with activities of daily living, dressing, bathing, all that. They follow the requirements. They don't accept residents until they're licensed, just like a nursing home shouldn't take residents until they're licensed, which means The facility has completed all the training requirements, that the environment is safe, that they have med techs, they have CPR. Most of the assisted living residents these days have the same level of care of nursing home residents. And so it's really important that before an assisted living takes residence, that they have fulfilled all those requirements for the quality of life of the residents that live there and the safety of the residents. So what we find is that the assisted livings that accept people and don't have the licensure requirements, very few of them are ignorant of the law and aren't just, oh goodness, I didn't know that I needed to have an assisted living license. Most of them know that they're supposed to be licensed. They have a licensed facility and they traffic residents from the licensed facility to an unlicensed facility. They don't provide the care they need. They often take their benefits illegally. They become representative payee. In some cases, other really egregious actions have happened. They don't have qualified staff. They don't provide nutritious food. This law is to protect residents from assisted livings that don't have licenses. And actually, Ms. Kaufman, when she testified on it, she was talking about shouldn't, and she can correct me, but we shouldn't even call these assisted living providers. This isn't about, if you're in assisted living, you're supposed to know what the law requires and the COMAR requires before you open. And that's what this is about. This is not going to, and there are assisted livings that don't charge a lot of money that will take people that are licensed. And there are assisted living providers that are very expensive that are licensed. And the whole issue with housing is a whole different issue, because I'm concerned as well about the price of assisted livings and affordable care. So I share your concern about that, Delegate Riley. But I just wanted to say that this law is to protect the public against predatory behavior and poor care. And we see it all the time. One last thing, and I'll stop. Office of Healthcare Quality, part of their assisted living units, they have people that investigate these unlicensed allegations. And if you want numbers, they probably could give you that data. So thank you so much for listening to me. I greatly appreciate it. And I wish you all would consider supporting this bill.
Delegate Bandari and then
I'm
Riley.
sorry, the follow-up?
Delegate Bandari and then yourself.
Okay, great, thanks.
Thank you, Mr. Chair. This question is from Attorney General. So it means that we don't have authority now. The state, you guys don't have authority to investigate and prosecute unlicensed assisted living facilities where abuse or neglect has been found or occurred. We don't have anything currently.
Is that for me, Delegate Bandari?
No, Steve and Miss Alice.
Oh, okay.
So I'm the ombudsman. I don't represent the Attorney General's office, but you'd have to ask the Office of Healthcare Quality and the Office of Attorney General how they enforce this. But this actually adds added protections so that there are criminal actions that can take place against providers that either don't cooperate with Office of Healthcare Quality, because what we find out is these providers don't let OHCQ in, and then nothing happens. And this also adds additional provisions for this predatory behavior, whether it's exploitation, financial abuse, physical abuse. We've also seen real trafficking of people moving from one site to another, and then they disappear. We don't know where they are.
Okay.
And the AG's office may have something they want to add to that. I don't want to overstep my bounds by representing them.
Thank you.
Mr. Cameron?
Thank you, Mr. Chairman. So at present, an individual found to be operating an unlicensed assisted living facility is given a 30-day grace period in which to apply using those same COMAR regulations and the forms that Delegate Riley mentioned. But operators
excuse me. We're going to start voting in 2 minutes in the full committee. So I'm going to suspend this meeting, and everyone will get fair notice as to when we will reconvene, whether it's today or tomorrow. I don't know at this time, but I just got a note that voting will start promptly in the full committee at 2:45, and it's 2:43. Okay, we'll resume. Everyone will get due notice. You understand the conditions we're operating in. Thank you.
Thank you, Mr. Chairman.
We are adjourned.